Good afternoon, everyone. My name is Dr. Danielle Tolson Cooper, and I will be your moderator for today's event. We are here to talk about experience from practicing restorative justice for sexual harm, trauma, justice needs, participant satisfaction, equity law, and the future. As I mentioned, I'm going to serve as your moderator today. We have a robust array of guests that I can't wait to tell you more about. But before we do, I'd like to turn it over to Cindy Prizio and Senator Gary Winfield for a welcome.
Good afternoon and welcome. My name is Cindy Prizio, and I am Executive Director of One Standard of Justice. Thank you for being here today as we present our third of 5 webinars on the subject of sexual harm. The series is explicitly meant to provide a factual underpinning to a new collaborative conversation on how we deal with this emotional issue. In our first webinar, we heard from Dr. Carl Hansen, who is the co-developer of the world's most widely used risk assessment tool, Static 99R. Dr. Hansen spoke about the low recidivism rate of people who commit sexual offenses and how even the highest risk person becomes less of a threat the longer they stay offense-free in the community. In our second webinar, we heard from Katie Gotch, a leading treatment provider, public policy executive board member of the Association for the Treatment of Sexual Abuse, ATSA. She spoke about ATSA's most recent research paper, which found the sex offense registry does not make our communities safer, while also creating a significant additional harm. Today, we take a different approach. Data shows our current adjudication system doesn't always meet the standards of delivering justice or fostering active accountability. There are alternatives. Restorative justice focuses on who was hurt and how do we make the person whole or repair the harm done, rather than the current criminal legal system, which asks what crime has been committed, who did it, and what's the punishment. Restorative justice engages the primary stakeholders together with their family members and the community. Today, we will be given a vision of what can be accomplished through the experience of our presenters. Like most states, Connecticut has created an enormously expensive adjudication scheme surrounding sexual harm that has little impact on the rate of sexual offending. And it often doesn't meet the needs of either the person harmed or the one doing the harm. We appreciate the time legislators, policymakers, the legal community, practitioners, and other professionals and interested parties have taken to be here. If you missed our first 2 webinars, they are available on our website, onestandardofjustice.org. We hope these webinars have provided useful information. There is wide acceptance that our mass incarceration strategies of the past have inflicted massive costs on not only our state, but our families and communities, and that reform is much needed. The field of sexual offending is no different. We are a civil rights organization that educates and advocates for those who have committed sexual harm and their families and communities. We also are advocates for reducing or eliminating sexual harm. We believe a research-driven approach to offending can bring enormous monetary and non-monetary savings while allowing more funding for upstream education efforts and lowering rates of offending. Our 4th webinar will be on May 3rd, when a woman who identifies as a victim of sexual violence takes us on her journey to find justice. My profound thanks to our speakers, Mary, Laura, Kate, Elise, and Quince, also known as our Dream Team. Dr. Mary Koss, thank you for your leadership, guidance, and vision throughout the making of this webinar, a webinar we can all be proud of. And special thanks to Dr. Danielle Cooper of the University of New Haven, who is with us moderating and enhancing this important conversation. Now my final responsibility is to introduce Senator Gary Winfield. I first met him at the Legislative Office Building and invited him to attend an emotional support group meeting, Fearless, or also known as Fearless, to watch a documentary called Untouchable with men and women on the registry and their families. As I was reminded yesterday by my old friend and mentor who drove down from New Hampshire for this event, it speaks volumes about this man who left his family on a Saturday night to sit down with people who are judged by many as the worst of the worst. What struck me that night and has stayed with me is this man's generous humility and his willingness to put aside other people's judgments and actually listen. I'm delighted to introduce Senator Winfield, who is co-sponsoring this series of webinars with One Standard of Justice, despite being smack in the middle of the 2021 legislative session. Senator Winfield, I've been waiting for years to say this to you. Your 3 minutes begin now.
That's actually quite funny. And if you know the legislature, you know why that's funny. Let me thank Cindy for constantly reminding me that there is more work to do. I think she thinks she bugs me, but she doesn't, because this work is important. Let me thank Dr. Cooper, who's been with us through the series. She's phenomenal at leading us in these discussions. And let me thank the rest of the panelists. I want to be really quick because there's a lot of stuff that I really want to hear. I think the way that these discussions are broken down, we've learned that what we think we know about recidivism, we probably don't know. We've learned that what we think we know about reentry and whether we're safe or not, based on the fact that we have a registry, we probably don't know. Now, some of us knew that, right? But many of the people who are in these discussions are speaking without real information, are speaking without real facts. And one of the reasons why I showed up that night was, I think the more information we have, the better we are and the more safe we will actually be. And I just want to briefly just say this. It has become more and more important to me that we deal with the issues that we're talking about in this series. The other day I was chairing the Judiciary Committee, and I kept hearing people talk about the victims, and how people like myself don't care about the victims. And then it just hit me. You know, I think a lot of the times we say they don't get it. They don't understand my side, my perspective. But it really hit me what that means. Because what I came to understand in that moment, maybe I should have just picked this up earlier, what I came to understand in that moment is they don't understand that I'm a victim. That because I grew up in the community I grew up in, I have a perspective as a victim. I told Cindy this the other day. I used to sleep with a knife underneath my bed so that in case someone came into my house, which they often did, I felt protected. When I would go to school, sometimes I'd get a free day off from school because we didn't have a car. And I could go down a list of things, including a sexual abuse in my past that many people now know about. The point that I'm making is that because I have that perspective, I know that people can view people a certain way and not understand because they haven't endeavored to understand, because they've used the kind of painting that we often do of people that isn't real. And that's what's done with the population that we're talking about. And while we think we're safe, it makes us much more in danger. And part of the work that I want to do before I leave the legislature is help us to understand what's really going on with these populations, who these people, and I say people, actually are. So I want to thank all of you for giving me an opportunity to sit here and listen and learn and maybe respond a little bit later. And I think with that, we're going back to Dr. Cooper.
Great job, everyone. I just want to give a few housekeeping reminders to everyone. This is a recorded webinar. You will be able to access this recording later. And we also want to just thank you, Cindy. Thank you, Senator Winfield, for really setting the tone for this important discussion. You all raised the importance of acknowledging not only what does it mean as we discuss individuals who are convicted or registered of different types of offenses, but how do we also address the harm? What do we need to learn? What are the questions that we can ask? And we have a jam-packed session in order to get that done. And so I will just jump right to it, and I will pass next to Laura Sinko. Thank you, Laura.
Sure. Thank you, Dr. Cooper. and Senator Winfield and Cindy, thanks for having us. So my name is Laura Sinko, and I am a sexual assault nurse examiner, as well as a researcher at the University of Pennsylvania. And today I'm going to be talking about trauma and how it impacts folks. Here's a quick overview of our agenda for today. I will be starting, and then we'll be moving through the list of our speakers. So let's start by talking about what is trauma. And so I think when we're thinking about trauma, we often conceptualize the events. And we know that events can certainly cause trauma, but beyond that, how someone experiences an event really can determine whether or not it's traumatic. And ultimately that effect is what is considered more longer lasting. And so it's important when we're thinking about trauma that not all events impact people the same. And so that can explain why sometimes when two people experience very similar events, they might have different reactions. One might not even consider it traumatic, and one can have serious lasting implications. It's also important to consider the intersection of identity and trauma. And so depending on the different identities that you hold, it can impact your risk of actually being impacted by a traumatic event, but it can also impact the way you want to seek help or heal after these experiences. And so there are many different types of trauma. There are more personal or private events, but there's also public traumas and events that people can experience. For the purpose of today, we're really going to zoom in on sexual harm and how the trauma surrounding that can impact people. So I'm going to play a video now that was actually produced in Scotland for law enforcement, but I think it gives a lot of really important information on trauma and how it can impact the brain as well as our reactions. So take a listen.
We need to take a statement so we can establish what happened on Saturday night.
What time did you get back to David's flat? What time? I don't know.
Can you give us an estimate?
I don't remember.
Would your pals remember what time you left the club?
He seemed nice.
She didn't remember much, did she?
I know. And now we've got to waste more time on a daft lecture. We know how to deal with victims. We've had years of experience.
Well, some of us have had more years than others.
I'm in my prime, I'll have you know.
That'll be right.
Today's session is about trauma. The latest in brain science will help you in your work. I'll start with a tour of the parts of the human brain. The reptilian brain maintains basic bodily functions. The limbic system is also instinctive. It deals with fear and pleasure. For example, you pat a dog, it senses pleasure, and without thinking, wags its tail. The neocortex is the site of logic, imagination, planning, and control. It's more sophisticated, but because it's conscious, it's slower than the older parts of the brain. The amygdala is a key part of the limbic system. It has one job: to sense danger and set off the alarm. When it's a matter of survival, the primitive parts of the brain override the conscious part. There are three possible survival responses: fight, flight, or the one that people don't think of, freeze. When the alarm goes off, blood and oxygen are diverted to muscles, adrenaline floods the body, and all systems that are not crucial to survival are switched off. Normally, the job of the hippocampus is to file memories so you can retrieve them later, but in times of danger, it stops filing memories, which makes it harder to gather evidence later on. Instead, the hippocampus switches to pumping cortisol. What's useful about cortisol is it stops us feeling pain, so we can focus on survival. Can anyone give me an example?
A farming accident where a man carried his own arm for a mile without feeling any pain?
Yes, excellent example. It is an evolutionary safety mechanism which is fast and instinctive. In essence, it's our body's very clever way of protecting us. To recap, An example of the three parts of the brain working together. You're standing at a bar. Your reptilian brain is keeping your heart beating. You're enjoying the pleasure of a nice pint with your limbic system. You're using your neocortex to work out if there's time for another before the last train. What could happen to make the amygdala kick in? What if this happened? The way you'd respond would depend not on your logical brain, but on your instinctive brain. Being glassed in a bar would be a traumatic experience. Who can give me another example of an event that can cause trauma?
War?
Rape?
A car crash?
Good, yes. Trauma occurs when a person is overwhelmed by something beyond their control. The survival brain takes over the rational brain. It can lead to post-traumatic stress disorder, PTSD, with symptoms that last at least a month. Vicarious or secondary trauma is something you may experience if you deal with incidents such as rape or sudden death, or think of Lockerbie, Dunblane. You're not superheroes. Having a brain makes you all vulnerable to secondary trauma. It's important to understand that when trauma occurs again and again, it can become complex PTSD, such as in domestic abuse or child sexual abuse. The alarm system in the brain becomes jammed. Memories are stuck in the limbic system, so a trigger can set off the alarm. The trigger could be anything: a colour, a smell, a sound, a sensation. Now, the indicators of trauma. What should you be looking out for?
Depression. Crying a lot?
Yes, that's one response. And at the other end of the spectrum, total numbness.
Nightmares? Flashbacks?
Stress.
Good, yes. And they may feel sick. Also, shame, feelings of guilt, inability to enjoy sex, social isolation, triggers. People often feel overwhelmed by the symptoms of trauma. This can lead to using alcohol or other drugs to block out memories, or self-harm, or dissociation when a person's mind detaches from reality. Indicators can be specific to the type of trauma. Say, dental problems, when someone who was orally abused avoids going to the dentist. A victim of abuse might bond strongly to her abuser. This is known as traumatic bonding, or Stockholm syndrome. And jumbled up memory, when a person's normal recording of memories doesn't work. Can you recall any times you've seen that symptom?
What time? I don't know.
A traumatized person may not seem like her usual self, or may be hypervigilant, on edge, or being startled by everyday things. Everyone is different. You never know what impact trauma will have. Symptoms can change from day to day. So what does all this mean in practice, in your job? A traumatized person's brain is protecting them, but that normal human response of self-protection can get in the way of evidence gathering. The US military has developed new trauma-informed interviewing techniques that you can use to work around this. Research shows that if someone seems vacant, they could be distracted by their traumatic memories. Try to ground them by asking a simple, non-patronizing question such as, "Are you thirsty? Do you want a glass of water?" This can help bring them back to the here and now. Don't expect a logical, linear story. Ask, "What can you recall just now?" Find out what the victim physically felt or saw. Working this way, from the instinctive sensory parts towards the logical parts of the brain, you'll get more results. In conclusion, 4 things for you to take away. Trauma response is the brain in survival mode. Repeated abuse can make trauma symptoms worse. In response to trauma, people will behave in unexpected ways. Remember, trauma is a normal human response to abnormal events.
So thank you for listening to that. So it's important to recognize with trauma that no one is immune to trauma, and often those who experience trauma can unintentionally or intentionally cause trauma to other people, because we know people who experience harm can often cause harm as a result. And so Now we're going to talk specifically about sexual violence, and that's the expression of power and dominance, most commonly by men over women or individuals of other genders, although men can most certainly experience sexual violence. So we know that nearly 23 million women and 1.7 million men have been victims of rape or attempted rape at some point in their lives. And for every 1,000 assaults, around 230 are actually reported and 5 will result in incarceration. And so even for situations that do result in a criminal justice outcome, many survivors reflect that it might not be the outcome that they wanted. For example, you can see to the right, one survivor reflected in a study, even if you receive justice through the criminal justice system, is it the kind of justice that you wanted? Maybe not necessarily. And so what are survivors' justice desires? Survivors want a variety of things we found based on our research. So one big thing is recognition, recognizing the harm that occurred, having voice throughout the process, being treated with dignity, a focus on prevention and making sure something like this does not happen again, some sort of consequences that surround active accountability rather than just punishment for punishment itself. And then a feeling of connectedness to really experience that feeling of wholeness that they're really looking for in their healing. And so why is the criminal justice system not working for survivors? So we know to start, individuals with marginalized identities often do not feel safe working with law enforcement. We also know that survivors in general anticipate some negative treatment from these systems and maybe think that they're not going to be believed, so they don't want to engage in it at all. Also, it's important to note for many survivors, incarceration is not the goal, and that points to a need for alternatives when we're thinking about justice holistically. Even survivors who do engage in the process, many cite a lack of control and voice and it not being what they expected. As you could see from our previous quotation, that even though they received some sort of justice, it wasn't necessarily the justice that they wanted. And then finally, there are many aspects of the system that can be re-traumatizing. And that can be from just telling your story over and over, to not being believed, to having to encounter the person that harmed you multiple times, and the list goes on. So now I will turn it over to Kate, who will share her experience with a qualitative study.
Thank you so much for that, Laura. Just real quick, my name is Kate Chisholm. I'm from the University of Arizona, and what I'm going to be talking about today is survivor victim perspectives, specifically regarding the criminal justice system and their perspectives on restorative justice from a recent qualitative study. All right, so to jump a little bit off of what Laura was speaking about, some of this is going to tie into that as well. The information I'm sharing comes from findings from a recent qualitative study conducted to better understand current perspectives from diverse victims of sexual assault on restorative justice, among some other topics. About half of the participants reported through the criminal system, while about half did not. And a few of the participants had heard of the concept of restorative justice before, but most had not. The participants were part of many online focus groups and were all given a brief presentation about the basics of restorative justice before being asked on their opinions of if it interested them, why or why not, and logistically where they would like to see it housed. So the goal of the study was three-pronged. First, again, to understand the aspect of restorative justice from their perspective. Secondly, for those who did report to the criminal system, what their experience was like and how they could envision minimizing or repairing the known harms of participating in that system that they may have also experienced. And third, to understand what goals they had outside of reporting and how they hope to find their own sense of justice and closure without dealing with any kind of system. So while I'm going to be focusing primarily on the participants' perspectives of restorative justice, I'd also like to start with their perspectives of the criminal legal system and experiences with that, because it highlights from survivor victims' eyes, really, why alternative justice seeking mechanisms are so important to have in the conversation as an option for the future. So the bottom line really is that the criminal justice system does not always align with survivor interests. There are many reasons that sex crimes are unreported, as we heard from Laura before. And I'll be getting into those a little bit more as well. As you can see, there are some quotes from the study that are here on the screen to help kind of drive these points home. A lot of the people who went through it in the study, as commonly known, found the system to be further traumatizing. Alternatively, restorative justice had justice interests that often aligned with the goals of people who participate in restorative justice that other researchers have found. So those justice interests would include survivor victims having voice, validation, a sense of participation in the process, and the ability to have the offender take accountability or responsibility in some way. And of course, survivors have goals outside of dealing with those systems at all, but we'll be getting to those in a little bit later. So to first go back to the criminal system and to put to words some of the themes that emerge from this study that match very well with research that we've seen a little bit of already. Many participants in this study described feeling harmed by actors in the criminal legal system. And that included police officers, detectives, attorneys, and even judges in a variety of different ways. They perceive systems as a whole, including family court and criminal court, to be broken and oftentimes oppressive. Some instances of mistreatment included being dismissed or disbelieved, being subjected to prolonged legal processes without adequate support, being withheld medical care or forensic exams, being discouraged from reporting, finding errors or inaccuracies in police reports, and feeling as though the officers primarily protected the offender or acted in self-preservation of the police division that they were working with. So ultimately, participants perceived the criminal system as basically kind of an additional perpetrator and sort of this looming entity that they didn't have any protection or recourse from. So kind of to go off of a little bit more deeply how some participants viewed the criminal justice system as an additional and separate perpetrator. Not a single person that participated in this study did have a positive experience with the criminal justice system. The quotes on the screen speak to the main points that were often echoed by others. And again, this does fit with what we already know so much about this research. And the trust in the system is very low, which is noted by having that approximate 23% reporting rate nationally. Many other participants also noted a lack of follow-up and feeling like they had to basically collect their own evidence, track their detectives down, often to no avail, to just be given an update in their case, and really just had little help as a whole navigating any part of reporting, not having an advocate and not having any kind of assigned attorney or best interest person to help them understand what was going on in the system, how to navigate it, and how to best be heard. So in regards to the harm caused by the criminal system, a major finding was the lack of trust that survivors felt in many ways afterwards, not just with the system, but more than one participant had an offender who worked in law enforcement, and then going through that system, having these particular offenders often cause people to lose trust in others altogether for a very extended period of time. The perspective of participants about criminal justice and how it affected them could be a lengthy presentation in itself, but to move along, when participants were asked how they could envision minimizing or repairing the harm they endured by reporting and moving through the criminal system, it actually brought more to light about the issues that they encountered while going through the criminal system. So many participants felt that the judges they encountered did not have the subject matter expertise to be dealing with certain critical aspects of their cases, as often demonstrated by one quote currently on the screen. Others did not feel that police, detectives, or attorneys had the training necessary to handle their cases, and especially when it came to sexual misconduct, different aspects of that, and they were not certain if training could truly be beneficial anymore. So to sort of sum up perspectives on criminal justice, when it came to repairing harm, the main finding was that participants already did not trust the system, had already oftentimes been greatly hurt by the system, and very often did not feel that repairing harm could be done. A few participants, though, did have some interesting ideas about how they could repair harm and mentioned maybe using some kind of form of restorative justice with institutions or people within those institutions to possibly repair harm. So that's just one instance of how potentially that could be creatively used in the future. But honestly, most people were very skeptical that the participants could be genuine and authentic, and they were skeptical that they would receive that basic acknowledgement of harm and respect from anyone they encountered within the criminal system. That was very difficult for them to conceptualize. So overall, the survivor victims in this study felt that the criminal system is just simply not listening, and that was shared by many participants. So given the negative outcomes and experiences participants had with the criminal system, and knowing from research that similar issues have come up in several studies in various parts of the country, it makes sense that alternative justice seeking mechanisms should be explored. This is where restorative justice comes in as a very promising alternative, and the logistics of restorative justice will be explored in more detail a little bit later on through other presenters. But essentially, in terms of this study, what we're talking about is restorative justice conferencing. And this refers to bringing the person harmed and the person responsible together for a process that includes preparation, a facilitated dialogue, potentially involving other members of their families or community members who were affected, and a post-conference phase for monitoring, and then finally an evaluation. So both the victim and offender would have to be willing to participate, which is important to note, and its programming seeks to repair harm rather than assign blame. It's very different from the criminal system approach. So the results from this study were very mixed, but generally positive. So to start with the positive, several participants felt that being able to speak with the offender in a controlled setting would be helpful to them. As one participant clearly stated, it would have helped given her voice and participation. And that was echoed by other participants. Many also expressed that being validated by their experiences and having the community and family members both hear them and understand them would contribute to positive outcomes for restorative justice. Participants also expressed an interest in being able to actively participate in this process rather than being merely seen as a witness, and felt that acknowledgement of the harm could bring them closure. Some participants saw this as a positive alternative altogether to the criminal system. Participants had many reasons for holding this belief. One person here talked about how restorative justice was more in alignment with her goals and outcomes of the criminal legal system. It was acknowledged by several participants that they did not feel imprisonment would be rehabilitative or healing for anyone, themselves or the offender included, and that restorative justice held the potential to offer a deeper level of healing for everyone involved. The concept that not everyone wanted someone that harmed them to go to jail was something that was stated again by multiple people. Many participants had no interest in taking part in the criminal system whatsoever, especially when the person who harmed them oftentimes was a family member or someone that they cared about. Many participants stated they felt that restorative justice could offer a pathway forward for everyone involved that would not be re-traumatizing. And these findings are typically found to be true as alluring options, kind of generally speaking, from other research on restorative justice. However, it is important to note that not everybody had positive feelings about restorative justice. One of the most common findings was many participants didn't believe that the person who harmed them could acknowledge the harm, and many participants had concerns that the person who harmed them might be too violent, or might be too manipulative or sociopathic to participate. Many participants did not believe that the person who harmed them had the capacity to truly understand how their actions impacted them, and didn't believe that they would be able to authentically participate in the process or would be willing to at all. So something important to note, though, is that while many of the participants would not consider going through restorative justice themselves, almost every single participant was open to the idea of restorative justice existing as an option for others. Even some of the participants with conflicting feelings, or who initially didn't like the concept of restorative justice, wanted to believe there were better alternatives to imprisonment. As one participant said here, there's also a part of me that would like to believe that this is more positive for our world than putting people in jail. So having that greater perspective came up quite a bit. It is important to note that there were many concerns, questions, and misconceptions about restorative justice. So that highlights the need for some further education. Many participants expressed that restorative justice was perceived by them as harmful, unsafe, or impossible, or unhelpful. And commonly cited reasons for that would be having a repeat or a highly dangerous offender or highly violent offender, which is something that would be typically exclude someone for participation in the first place. But others were also having concerns about power dynamics, such as people associated with a powerful institution or someone's age. They were concerned that some participants on the survivor end of the spectrum might be kind of forced into it, even if it wasn't something that they necessarily wanted to do, but might be pressured. And others felt that it just wouldn't be helpful to them personally. They couldn't conceptualize meaningful consequences. They couldn't see this being something that they would want to stick with for an extended period of time. And they also some of them didn't want to be in the same room as the person who harmed them again. So a lot of those common questions of how to kind of handle these situations I see are going to be coming up a little bit later in this conversation by some other presenters. And I just sort of wanted to end on the topic of key informants. So there were some community-based advocates and programming coordinators and system-based advocates who were also asked about their perspectives on restorative justice. And it was interesting to note that in the community, there seemed to be more of a positive outlook on restorative justice when it came to providers, but there was still a lot of this lack of knowledge and an uncertainty for community buy-in and the capacity of the community to have these types of programs available. And for system-based advocates, there was a significantly larger lack of knowledge about restorative justice. It didn't feel possible to them, and that was largely based on some misconceptions that they carried. So that's something that we'll be talking about a little bit more, but as far as perspectives in this study that we learned from the survivor victims and a few key informants, this is what I have. So after that, I'll go ahead and hand it off to Dr. Mary Koss. Thank you.
Hi, everybody. I'm Mary Koss, and I'm a public health professional. Everybody knows by now that means we work in the community on real problems. So let me pick up where Kate left off and talk to you about a program that I actually ran for 5 years. In the criminal justice system, there's really only one customer. It's the defendant, and the purpose of the criminal justice system is to determine fault and to assign punishment. The victim has no other role and other than a witness for the prosecution. Some people have even said that the victim is cannon fodder, thrown out there for cross-examination. There are many restorative justice approaches under a big umbrella, but I'm going to talk about a certain specific one called the conference model. And restorative justice in general recognizes that there are more than one harmed person. There is a direct victim, but there are also secondary victims who are family and friends, and there are tertiary victims in the community. The offender is a constituent of this process, of course, but also the offender has family and friends who may feel great shame that this is happening to someone in their family. So take away from this slide that restorative justice, first of all, has more than one constituency. And second of all, it's non-adversarial. And third, it's based in the community. This is an outline of the stages of the Restore conference model. Restore is the name of the program. I'm only putting this up so that you can see that the conference itself is only a small part of a longer process where we ensure people know what's going to happen and are participating voluntarily, where they're prepared to come together face to face, and where the people who will be there are vetted so that those who are not going to be helpful and are possibly re-abusive can be excluded, or anyone that the victim doesn't want to have there can be excluded. The conference is actually the shortest part, and it is a face-to-face meeting as long as the victim, that's what he or she wants. They can be represented by someone else who reads a statement if they prefer not to be in the room. The longest part of the process is supervision and reintegration of what we call the responsible person into the community. And this, I will say more about what they do. It's a 12-month time frame. I'll say more what they do in just a minute. Kate mentioned that there's a lot of misunderstanding about restorative justice conferencing. So let me emphasize just a few things. You need a lot of training, both in restorative methods and also in sexual assault. Not everybody is appropriate for restorative justice. So we're not suggesting that serial rapists, highly violent rapists, participate in restorative conferencing. And finally, a primary consideration is the safety of everyone involved, but most particularly the direct victim from not only physical harm, that's very unlikely. What is more of a concern is emotional harm and verbal re-abuse. These are what restorative justice should be. Here are some people who are not appropriate for restorative justice. As far as survivor victims, the only important criteria is that it's what they want. Restorative justice, by definition, has to be voluntary. No one should ever be forced to choose this option. Even though criminal justice may not turn out well for them, people should have the right to do nothing or to choose alternatives if restorative justice doesn't sound like what they want. I'm not going to go over this slide in detail, but when I opened this program, restorative justice conferencing for sex crimes, both felony and misdemeanor, had never been tried anywhere in the world with adults. And we found that the models of conferencing that had been used in other places were based on juvenile cases. They just couldn't be taken down off the shelf and rolled out for adult people. There's actually 39 concerns. I put up some victim concerns, some concerns from, again, what we call the responsible person. We wanted to differentiate from the criminal justice system and not call people offenders or defendants. There's many people who are concerned that restorative conferencing is soft justice, and they want to see the kind of punishment that the criminal justice can impose. But as Kate demonstrated, the criminal justice rarely does impose consequences. So they're only theoretical consequences. I would even say they're illusions. And for that reason, I'm a very big advocate of restorative justice conferencing. And it is a form of accountability that is not soft. I have on this slide the mandatory components of a redress plan that is a result of a restore conference. And as you can see, these are many more components than would typically happen to a non-highly violent rapist who ever came to trial. The agenda for the conference is people enter, perpetrators' family first, victims of family second, and victim has charge of whether she speaks first or whether the responsible person speaks first. He does not have to plead guilty, but he does have to accept responsibility, he or she, for what they have done, and state it in explicit terms, because their family and friends are there, as well as other representatives of the community. And it is a form of accountability to have it known what you did. The conference then moves on to planning the redress, which I just showed you. What I didn't have on that slide is that there are also victim components. So we had victims who wanted marriage retreat for the husband and wife because the husband was having a hard time adjusting. People who wanted a sentimental piece of jewelry replaced. People who wanted a contribution to their favorite charity. we found victims often had altruistic motives. They weren't seeking money for themselves. Well, what happened at the end of 12 months of supervision, during which they had monthly meetings and monthly meetings with the community board. They had, monthly in-face meetings with the social worker, weekly phone calls, and quarterly meetings with a community board of volunteers. It was only the community board that had the authority to terminate participation. And we wanted that because these responsible people were coming back into the community as with closure. They had completed their redress, they had done their accountability, and now they were being restored to the community. So it should be a community decision if somebody is not making progress, not complying. We had, as you can see, the majority of people successfully completed that redress plan that I previously showed. We, not claiming to be the magic formula, because we had some reoffending, and we also had some people who were terminated. For one, we asked to terminate because at the 11th month and the 29th day of a year, this individual basically recanted his responsibility. And we asked him, you know, we don't want to count you as a success of the program. You're not a success, and you have the right to withdraw. And, you know, and so that person is reflected in the people who were not successful completers of the program. People are really worried about, is this approach, I mean, face to face in a room with a person who harmed you in this intimate way, is that harmful to women? Well, certainly we did track how the victims psychologically, how their psychological health was as they went through our process. And in this graph, I'm just illustrating for you, compared to the first 3 months in a rape crisis center experiencing counseling, this is the percentage of diagnosable post-traumatic stress symptoms that were observed in the participants of our program versus the participants in a rape crisis center. So all I can claim from this is you can see that it did not make people worse. And counseling and justice are very different things. So for that reason, no one claims that that Restore is a treatment for post-traumatic stress disorder, but at least this is some kind of concrete evidence that we didn't create more trauma in people than they came in with. We did a survey of all the participants regarding their satisfaction. And that's why for some of these figures, there's a range, because I'm telling you how many agreed or strongly agreed or agreed on each of these justice outcomes. And I think you wouldn't be surprised to know that in some that responsible people and their families were not always as satisfied as victims were. And furthermore, victim representatives, who oftentimes were advocates from our local rape crisis center, they were more skeptical than the victims themselves. However, as you can see from the range, I mean, considering that this is a justice process, and considering that this process applies a rigorous accountability plan, these are pretty amazing ratings of being satisfied or fully satisfied with the justice process. Here's some really important points that connect with what is going on in our time. And that I'm going to go through each one because they are so important. First of all, please don't get threatened by restorative justice. It's not a replacement for adversarial justice. It's an option on a menu. What are some of the advantages? Criminal justice process has its own language, its formal procedures. It is so intimidating to people who don't have training as a law enforcement officer or a lawyer. In criminal justice proceedings, pretty much all the time, defense attorneys push defendants to plead not guilty. This creates an absolutely immediate feeling in the victim of, I'm not validated. This person will not even, accept that it happened. And they're saying, in fact, that they're not guilty of what happened. Restorative justice only asks people to acknowledge that the act happened. It is not the equivalent, as Quince will point out, of a guilty plea. And therefore, it gives the opportunity for victims right from the start to feel they're in a system that's tilted more in their direction, and that from day one, they are believed and they are considered a legitimate victim. That also affects their families, because families are a lot more likely to support you and to be patient about your recovery if they sense that the system believes you and treats you as a real victim. Otherwise, victims tend to report that not all their peers or family were supportive. In fact, they experienced self-blame by a lot of people. And related to this point is the next one, which is that our criminal courts are set up with carceral destiny. That's many times what prosecutors are seeking from the criminal justice from a trial. And restorative justice is a non-carceral approach. It recognizes the harm of disconnecting those responsible from their family, from their children, from their jobs, from their communities, and then trying to reintroduce them later under a lot of restrictions that generally cause them to affiliate with other sex offenders, as opposed to affiliating and feeling reintegrated into the healthy segments and the people who are supportive of them in their own community. And I think it's also important to emphasize that there are so many professions that if you have a conviction or actually even a report of a sex crime, it interferes with your employability. And restorative justice, I could tell more later, it was retrievable by police officers, but it did not create a formal record that would interfere with a responsible person's future employability on the condition that they completed the program and that they did not reoffend. The last point on this slide is that it's very important we know this about teenagers, but it's important to recognize this is true about all people, is that we pay more attention to the communities that are similar to us and the communities that speak our language, share our ethnicity, know our living circumstances. This methodology of RJ conferencing involves the community I perhaps shouldn't have used the word policing, but maybe that emphasizes to you, I'm not suggesting replacing the criminal justice system, but offering an alternative in appropriate cases to involve the community in enforcing the norms that laws codify. And now I'm going to show you this one last slide, which was made by a participant of our program for the Clothesline Project that during Rape Awareness Month is held every year. I want you to pay attention that she articulates that she experienced restorative justice as something that was forward-looking. It did not go back and adjudicate evidence. It started with, this happened. Now, let's plan for how to ensure that the person responsible understands what they did and that they take appropriate steps to rehabilitate themselves. So it's forward looking. The fact that the Band-Aid is there, well, it's not to say that when you take it off, there will be no scar, because no justice process, and for that matter, no psychological therapy process, is a cure-all that will make everything better again. The Restore program was quite successful in bringing victims a sense of resolution, but hopefully left them with a small scar that looked like a cosmetic surgeon did it. That as they move forward, and victims do move forward in their lives, and oftentimes they move forward in their lives in a better way because they have been empowered by having something happen that validated them, that made them feel like, okay, I can put this behind me now. And that's the last thing I want to say, is just try to be humble about the claims of restorative justice. It is a justice process, and it's not a magic elixir that is a cure-all. But I'm still in love with it. I'd like to now turn over to Dr. Elise Lopez, who is going to talk about what she tells you she's going to talk about.
All right, thanks, Mary. So before we move on, what I'm going to be talking about is restorative justice on college campuses. And college campuses are a little bit different of an environment for how these cases are addressed and what they look like compared to what we've talked about already, which is mostly focused on the community and the criminal justice system. And a lot of restorative justice programs that are starting to pop up on college campuses borrow heavily from the Restore program. So I was really glad that Mary was able to talk before me so that she could explain what that program looked like and the foundations of it. So before we get into why we would use RJ on college campuses, I want to talk a little bit about why campuses adjudicate sexual harm at all. This is a huge question that people ask all the time. Well, if this is a serious crime, why are college campuses? Why do they have anything to do with this? Why don't they just hand it off to police? And the reason for that is that the criminal justice system is addressing crimes, things that are listed out in statutes, they're defined there, and they have defined sanctions according to the criminal code. College campuses, on the other hand, are not adjudicating crimes. They're not looking, when sexual harm is reported to them, they're not looking at whether a crime was committed. On college campuses, there's a code of conduct that students are expected to follow, and it covers a whole range of things for how we expect students to behave on campus. And so when we're talking about sexual harm, dating violence, anything like that, that can be a violation of the student code of conduct. So what we're looking at then is a conduct violation, and the process is called an accountability process. So that's what our adjudication process is called on college campuses. We want to hold people accountable for adhering to the student code of conduct. And if they violate that student code of conduct, that there's an accountability process after that by which they are held accountable for their actions in some way. So some types of sexual harm qualify as both a crime and sexual misconduct. For example, rape or attempted rape could be addressed in either of those systems. There are things that may be sexual misconduct on a college campus that don't necessarily rise to the level of a crime. So for example, somebody sending someone else an unwanted picture of their genitals without that person's consent will probably be a code of conduct violation on a college campus, but it's not going to rise to the level of a crime in the community. Sometimes students report only to one of these systems. Sometimes they report to both, and sometimes they report to neither. So really there are multiple options that students have for reporting. And because each of these processes uses a different level of evidence to find someone responsible or in the community guilty of sexual harm, the systems may come to different conclusions as well. And what I have on the bottom of this slide are some terms you may hear if you're looking at campus sexual assault work. So in a lot of these processes, the traditional terminology is complainant, respondent, and then the process, the reporting is called a grievance process. And you can see how these words might create some bias for or against different people in that process. So some of the other terminology that is starting to come up for campus-based adjudication are reporting party, reported party or responding party, and the process itself being called the reporting and adjudication process. When we look at restorative justice, the terminology that you've heard so far are things like harmed person, victim, survivor, the responsible person, and the process sometimes being called on campuses, a resolution process is another thing you might hear. There we go. One of the things you might have heard a whole lot about, especially in recent years, is Title IX, and how that is related to campus sexual assault remains a mystery to many people. So I'm going to give you a quick and dirty Title IX primer, and here's what that's about. We're not going to go into it in major detail, but we can certainly talk about it in the Q&A portion if you want to. So here's the thing with Title IX. It is not a sexual assault, sexual misconduct regulation. Basically, what it says is that people cannot be discriminated against on the basis of sex in any educational program or activity that receives federal financial assistance. Mostly in the past, people heard Title IX and thought of it about equity for women in sports on college campuses. But over the years, it has been used for sexual misconduct, sexual harassment on college campuses. So these types of cases have fallen under the purview of schools because of Title IX. There have been some major regulatory changes, as you might have heard, over the last year regarding Title IX. Here are some of the big ones you may have heard of and what they mean. So first of all, the definition of what counts as a Title IX case has narrowed a lot. So previously, students who reported a sexual assault that occurred anywhere, on campus, off campus, could report that to the institution, and a Title IX investigator would investigate that case. Now, cases that occur off campus are not Title IX cases because they are not happening at an educational institution or during an activity of the educational institution. So under Title IX, schools are not required to address those cases anymore. However, schools can still address those cases through their code of conduct, and they are still doing that. But a lot of students now are under the impression they've heard Title IX narrowed, they think their case can't be reported to the institution. Students can no longer file formal anonymous complaints. So they used to be able to make reports anonymously about someone who had harmed them, or maybe multiple people might report anonymously. They can no longer do that and expect that a formal investigation will happen. They can report anonymously and still receive supportive measures, but that's as far as that's going to go. Schools can no longer decide what their own adversarial process is going to look like. So they must have an investigation process and they must have a live hearing. And live hearings can include cross-examination of both parties by that party's advisor. And an advisor can be basically anyone, that's not defined. It can be an advocate, it could be an attorney. So it's become very quasi-criminal justice oriented. However, students can choose what's called informal resolution if a school offers it. I hate that title because it makes it sound less than, or that it is not a form of justice for people, but this can include restorative justice. What restorative justice is not defined in those new regulations, but it has opened the door for restorative justice. And there are a lot of schools that are starting to create these policies and programs, which is very cool. So why would we consider restorative justice for campus sexual misconduct? First of all, from a survivor perspective, as Kate talked about as well, survivors are often very jaded by adversarial adjudication, which they might call the Title IX process. Right now, especially, there's a huge over-alignment with the criminal justice system. We know that these new regulations are having a chilling effect on survivors wanting to report. They have a fear of an adversarial process and may decide that reporting to that system is going to be more re-traumatizing to them. We, as Mary talked about when talking about restorative justice may provide a greater sense of justice for survivors, especially in terms of things like feeling heard, feeling like there's some resolution to what happened to them. And also, we often on college campuses have respondents who acknowledge the harm done. They may be surprised that they were reported for something that they thought was consensual, for example. And does that mean that if they thought it, like legitimately thought it was consensual, does that mean that that's an excuse? No, it doesn't. But if you have someone who acknowledges that they did something harmful to someone else, why do you need an adversarial process that is not going to allow that person to take responsibility for what they did? So without this option, there really is no reason that somebody would choose to take responsibility for what they did, even if they believe that it was harmful. It's really excellent for addressing community level harms. So what I mean by that is on college campuses, First Amendment protects freedom of expression, right? Just like it does anywhere else. And as for public universities, what that means for us is that it's not a code of conduct violation when somebody says something offensive or does something like hang up a rape promoting slogan on a banner, things like that that might be protected speech, but are still harmful to the campus community. You can create restorative justice processes that are voluntary that can help people work through that and the harm that that behavior has caused. Restorative justice can also help us to meet our goals as institutions of higher education. We know that especially with undergraduate students who are still in that late adolescence period, risky behavior is developmentally appropriate. And so, for example, We have a lot of students who maybe both drink heavily and a sexual assault occurs. Again, not an excuse, but may help us to explain what happened. As educational institutions, our goal is to educate students and to help students, young people, to grow into healthy, safe, and responsible adults. And that should include learning how to take responsibility for their actions, and also know that they're going to be held accountable when they create harm in the world. And so restorative justice can help us to meet that goal when it is safe to do so, and when we have people who want to engage in that type of process. There are quite a few different ways that restorative justice can show up on college campuses for sexual misconduct. One is a resolution process. So this will be kind of like the restorative justice conferencing that was done through Restore. And this could be done in place of an adversarial adjudication process when we have people who voluntarily want to go through it. You have a respondent who acknowledges the harm that they caused and is willing to be held accountable for that and repairing that harm done. There are other ways of doing restorative justice for campus sexual misconduct that are not fully restorative, where you still had an adversarial process that happened, but you may do things like in the sanctioning process, a survivor may have input into what feels like justice for them, and that's reasonable to put into a sanction. There may be things happening later, like a victim impact process, which could be similar to victim offender dialogue. You can also do restorative justice within a reintegration process. A student may be suspended, temporarily excluded from campus, but they're going to come back to campus. So what can we put in place as part of sanctioning or as part of their reintegration that is going to help them to engage in behaviors that are not going to harm someone sexually in the future? So many ways that this can look, and we can certainly talk more about these during the Q&A. And what I want to end with are just some very basic guidelines for what campuses need to begin with if they're considering using restorative justice for sexual misconduct. One is formal staff training in restorative justice. As our other speakers have already talked about, this is critical. You can't just create a restorative justice program and just throw in folks who don't have any actual training in that area for how to do that safely and effectively. Institutions need clear policies and procedures. So what kind of cases would be appropriate for restorative justice? How do we assess safety and risk ahead of time? What's going to happen afterward during a redress plan? How do we monitor that, et cetera? Voluntary participation, obviously. There has to be a preparation time with procedures and a reasonable timeline for that preparation. Safety procedures for the entire thing, figuring out what is follow-up and case management going to look like so that this person is actually being held accountable. And what happens if the responsible person decides, you know what, I don't want to go through with this. I'd rather just go through an investigation. Or maybe they're not following through with the accountability plan and what they were supposed to be doing to redress that harm. So what happens next then? And I am going to stop there and hand it off to my colleague, Quince Hopkins, who's going to talk about legal issues, many of which also apply to this setting. So I'm very glad to hand it off to you, Quince. Take it away.
Thank you, Elise. Yes, definitely excellent lead into what I will be talking about. So I'm Quince Hopkins, and I was the legal advisor for the Restore program that both Mary and Elise spoke about, and that you've heard a number of different things about. But I'm now the director of the Aaron Levitas Initiative for Sexual Assault Prevention at the University of Maryland School of Law, where I work with law students and social work students to engage with young people in Baltimore City, particularly middle school students, to use restorative practices in sexual assault and sexual harassment prevention. And then we're also in the process of morphing the Restore model into a restorative justice conferencing response to middle school peer-to-peer sexual harassment and assault. What I'm going to talk about here, as Elise said, we'll touch on some of the legal issues. I'm going to really just sort of skip across the top of the waves. Those who are lawyers or within the legal system, happy to answer more questions, more in-depth questions in the Q&A. But I also am posting in the chat an article that I've written about some of these legal issues with some more detail. But I want to say I'm just going to touch on a few topics, timing issues that come up in the restorative justice process, the involvement of lawyers, both for victims and for responsible parties, and some of the issues around confidentiality and privacy that come to mind. And then time permitting, either I'll talk now or when we circle back around about adapting to the youth context in cases of peer-to-peer harm. So to start out, I want to talk about the timing issues. And one thing to be aware of is, even though there have now been, since the Restore program was in operation in the early 2000s into mid 2000s, with additional research and reporting coming from Mary and other folks who've worked on it since then, up to the present day, there still is fairly little written about some of the really nitty-gritty legal issues that matter to lawyers and that matter to those within the legal system. So one of those that comes up is the issue around timing. There are issues that come up around civil action. So in some cases, if there's been a sexual assault, a survivor might wish to pursue a civil legal action, either against an individual or against an institution, say a school or a church or an organization that they feel that might have been responsible for creating an unsafe condition or something like that allowed for the sexual assault to happen. So there's statute of limitations on the civil side as well as on the criminal side. With situations involving serious allegations of rape, sometimes there are no statutes of limitation on the criminal side. It really just depends, and each state will have its own laws and limitations rules with, that are important for you to look at in your own individual state if you're interested in pursuing a restorative justice response. Another thing to be aware of is because restorative justice, as Mary talked about in the Restore program, we had a year-long process. Not only might limitations issues come up in terms of statutes of limitations, but there also might be questions about whether or not those statutes of limitations running have told or stopped or been put on hold, if you will, or whether they continue to run. And then questions about whether a participant, whether it's the survivor or whether it's the responsible party, might be willing to sign a waiver of a claim to raise a limitations type issue. Similar kinds of things come up in the context of speedy trial rights under state and the US Constitution. But part of the reason these issues come up is what Mary talked about, which is the process of restorative justice, if it's done well, takes time. It takes time, particularly around issues involving sexual harm. So because it takes time, it does raise some of these legal issues that need to be taken into account. So on the criminal side, you want to be asking questions about what's the point of referral into the restorative justice program? Is it pre-charging or is it post-charging or post-indictment? Because that will impact whether or not you have a timing issue. On the civil side, since restorative justice is really, and certainly Restore was this way as well, but restorative justice more generally is aiming to resolve all of the issues that might be existing between the parties around the incident that happened. That would include, conceptually at least, on the civil side as well, so that if you were to pursue a restorative justice in the criminal case, but you went ahead and that resolved the criminal case, but then someone was, say a survivor was to then pursue a civil action that continued the process going forward, you would not have had resolution. So what we did in Restore, and one thing to consider is whether or not the parties would agree to waive or forego a civil action involving the incidents that led to the case coming in front of you. So pay attention to whether you have those kinds of issues going on. The other thing to keep in mind, and that we took a lot of time thinking about, is whether or not the parties ought to, should, must have representation. And in our instance, what we did was we pursued, the type is fairly small here, but I'll just highlight what we did in response was, because there's a criminal case that could be pursued against the responsible party, the right to counsel, we set it up so that the right to counsel had been triggered, so that if a person had the ability to afford their own attorney, they would have their own attorney, but if they did not, that the public defender's office would provide representation. And that was done very consciously and in collaboration with both the private and public defense bars. We also felt, because the civil waiver was at issue for survivors, that survivors ought to have counsel to advise them about whether or not they wanted to go the restorative justice route, to learn about what the criminal justice process was going to look like for them, as well as whether to waive, whether it was a good idea or not a good idea to waive the right to a civil process. I've listed some of the other ideas of things that an attorney might want to address with the client. One last thing about that is that we worked on this with the survivors, worked with our local domestic violence shelter and attorneys, private attorneys that worked with victims that were coming through those shelters and through their legal advice clinics to provide that kind of advice. Second big area that comes up is around confidentiality. Victims often want to pursue restorative justice because they don't want to be in that public forum of the courtroom around the issues that they're going to be talking about. Responsible parties quite often are concerned about, are these things that happen either in my conversations with my therapist or in sex offender treatment that they might be required to go through to be in the program, are those statements going to come in to bite me on the backside down the road, or are the statements made in the conference, restorative justice conference itself, going to be used? And really, all of these kinds of things really come down to working with your prosecutor to come out with an MOU, a memorandum of understanding, memorandum of agreement, to resolve some of those issues. In the research side of things, because we were receiving federal funding from the Centers for Disease Control and Prevention, we also obtained what is referred to as a federal certificate of confidentiality to protect human subjects. That's not something that's going to affect most programs, but it is something that came up for us. The other things that come up, again, that I've mentioned a little bit already, have to do with the issue around use of statements in a later prosecution, again, through agreement. But you want to also be thinking about potential Fifth Amendment privilege against self-incrimination. Again, the advice of counsel for the parties that participate in the program can be invaluable in this process. We did make it a requirement in the Restore program that there needed to be an admission that the events had happened, with the understanding that the counseling, the therapy, the treatment that the responsible party would go through would help develop some of that awareness and cognitive understanding of what they had done and the harm that had been caused, so that by the time you hit the conference itself, there was not a question about whether something had happened or who was responsible for the harm that was done. So other kinds of things come up around that as well. Lastly, I just wanted to touch on, Mary talked about the fact that when we started Restore, that what had happened to date in restorative justice was mostly between youth or with youth as offenders. And so doing the Restore program was working with adults around these kinds of incidents. My program is currently engaged in a key informant interview project similar to what Kate talked about in terms of qualitative interviewing. And ours is not just in the US, but we're looking at and interviewing people internationally. And what the preliminary results of our study are showing is that even 20 years later, that restorative justice in cases of sexual harm for youth and adults is still something that programs shy away from. But in our program at the University of Maryland Law School, we are working with youth on peer-to-peer sexual harm. And the things that we are finding in adapting the Restore program to the youth context are the language itself needs to be adapted to the young folks that are going to be working with us. There's a lot of research around what that exactly looks like. Because you're dealing with youth, you have parents' rights and you have parental involvement. We're working in the school context, which Title IX, as Elise talked about, does come into play as well in the K through 12 context, but you also have parents involved in parents' rights around education. You have federal education privacy rights, FERPA rights, other kinds of things that come up. There are going to be possibly different services that are needed for the parties when you're dealing with young people as opposed to adults. And then the other is, say, in our particular program, who's impacted is going to be dependent on the context that we're working in a school, in a middle school in particular, and other students might be affected, other staff and teachers might be affected, administration might be affected, as well as the immediate folks who are involved in the process. The one upside of working in K through 12 context is that restorative justice in general has become much more common and much more kind of the cutting edge, really, around school discipline and disruption of the school to prison pipeline, those kinds of things. So what we are finding and what many might find working with young people in the school context will be that the schools themselves and the students, the young people, are used to restorative justice circles and conferencing compared to many adults that Kay talked about in the study, the qualitative study that she worked on and talked about. So with that, I am going to close, and I will turn over to Dr. Cooper, who will take us to our next phase.
I just want to say thank you to all of our panelists. You all have really blessed us over the past hour with a lot of information. I want to remind our attendees that if you have not yet posted a question in the Q&A session, we very much welcome your Q&As. But before we get to the Q&A, we want to continue to stay action-oriented and future-focused. That is where this work needs us to be in order to be problem solvers and to be building the communities that we are seeking to serve. And so I just want to pause and see if Senator Winfield would like to offer any remarks about the future and what we've learned here this afternoon.
I was about to do the same thing with the time, so you're good. Yeah, and thank you. And I want to thank all the presenters. I think there was a lot of really good information there. I think there's a lot that we have to do, and part of the issue that we have when it's this subject, again, goes back to my opening comments about what we understand about the populations involved on both sides of the issue, right? What we understand about those who we talk about as victims, what we understand about those who we talk about as perpetrators. And I think the General Assembly, where a lot of this action is going to actually happen, has to come to understand both sides in a different way. I do not think, in the presentations, the talk was about what some people have experienced, something we don't want anyone to experience, feel about the justice system, talking about the courts and police and all of that. But I've watched people come before the General Assembly, particularly the Judiciary Committee, where we're talking about these issues and whether we're going to change the laws, make them stronger or weaker, whatever the case may be. And they're used in ways to make examples. They're used in ways where people speak for them and they don't get to speak. And I think that the work is to change that. The work is to help people understand that is a portion of this, but their advocacy is larger than being there for the public hearing, than being a prop for one side or the other. And so my hope is that people recognize that whether you agree with people or not, it is better to have people who are in this process who have voice on both sides, and that we can engage in real conversation. So that's part of the work, and that the work doesn't begin next year when we have a bill or don't have a bill, but that work begins when this conference ends, of engaging with legislators who have a lot of things that they have to know. And this is not one that they know well. And so it's not rocket science here, right? It's sitting down, it's inviting your legislator to coffee, inviting your legislator to, have a donut, whatever the case may be, but talking to them about the realities that exist. Because as I said from the beginning, right, the victims aren't a monolith, perpetrators aren't a monolith. There are various shades of gray, and many of my colleagues see these things as black and white. And so the more work we can do to engage them, to get them to a place where they understand it isn't black and white, the better off and the safer we all will be.
Thank you so much, Senator Winfield. I will just add into some of your comments, really what I also see in terms of what we need for the future is this continued and shared discussion so that we can build language. Sometimes you and I operate in this justice, world, but whether it's because people have a narrow framing where they feel like it only operates in the justice world, no, restorative practices exist outside of that, whether they have a mindset of only some type of harm can be addressed by this, or only some type of offense can be addressed by this. We are seeing that our young kids are experiencing this in their classrooms as an opportunity for very simple behavior problems. And we're seeing this also being used for even more extreme types of offenses and much more severe harm in terms of what has been caused by individuals and the repair opportunity. And so thank you for sharing. I would take this time, I'm going to pass back to Laura. Laura, we'd love you to kick us off and share what can you share with us in terms of reflections for the future?
Sure, thank you so much for that. I can reflect in terms of healthcare, since that is where I mostly operate in. As I said, I am a sexual assault nurse examiner, and we recognize that whether you're operating in a system that whether you think you're interfaced with survivors or not, you typically do. A lot of folks experience different types of harm, particularly sexual harm. And so often healthcare providers are on the front lines for recognizing these things when they occur. So I hope that we as a healthcare unit can really improve not only our recognition of sexual violence, but also our response, not just screening for these things and then providing no follow-up, right? Because that happens sometimes, and that's not a place that we want to be in. I also think that we need greater awareness of just survivor justice options and what's available in the community. And I think we also need to advocate for policies that really prioritize survivor autonomy and the reintegration of all impacted parties back into the community. And I also think we have to think beyond traditional healthcare spaces to recognize the impact of incarceration on health outcomes, to try to see how we can really focus on these crimes and looking at them holistically and figuring out how do we support the health of all who are involved.
Thank you so much, Laura. I believe we're passing to Kate. Awesome.
Great.
Kate, share with us your reflections.
Sure, absolutely. So I would have to concur with what everyone said so far. I think that's beautifully well said. And I definitely agree that I think one of the biggest areas that I would like to see going forward are having more conversations with perspectives from survivor victims, perspectives from anybody who might be impacted or be able to participate in restorative justice. So just knowing from this one study that there were so many misconceptions and so many things that the average person didn't know, I think that speaks to the need for a lot of education and awareness around restorative justice. And there are some communities that are already very well aware, that are already doing that work, but there are so many that aren't. So I think that there's so much that can be learned from various people to be able to know how to best address those myths and also learn how to improve that process as an ongoing thing. So that's one thing that I would like to think about. And additionally, when introducing restorative justice, having ideas and kind of models such as Restore to be able to build off of or kind of implement in different ways, I think is really helpful, because logistically it was very hard for people to conceptualize on almost every level. So having those conversations as well. And lastly, I would just also like to say that The survivors in the study, the qualitative study, basically, honestly, when it came down to what their justice goals were, a lot of times it just came back to internally driven things. And that included advocacy and activism around basically preventing sexual misconduct before it starts. So these survivors were looking for very reasonable cultural change, having more and early conversations about consent, sex education, healthy relationships, and just building more community awareness so that there's like just a baseline level of empathy for people who have gone through any kind of sexual harm, and just to be able to integrate those experiences and those ideas into building healthier communities going forward, and maybe even avoiding some of these kind of backwards looking justice processes in the first place. So that's what I would have to say. And just thank you so much, everyone, for listening today.
Thank you so much, Kate. I would just quickly say in response, the research that you all highlighted as you presented today really allows people to break down their misunderstandings, address different myths that they kind of came to the conversation with. But also, a lot of people really want to know the research as it specifically addresses the people who have been the recipients of the sexual harm. And I think your work really does an important job of highlighting that work. Pass to Mary. Hi, Mary. What are your reflections?
Okay, well, I have 4 points that I would like to emphasize. The first one is, I wish I would get an opportunity to do this program in the United States somewhere. The Restore program operates and has continually operated for many years in Auckland, New Zealand. A variant of it operates in Melbourne, and we are in the process of setting it up in the whole state of Queensland, Australia. So I would really be happy if I got a chance to advise people on doing a program like Restore, but there are things I would change about it. Based on the experience of having done it for the number of years we did, there's definitely things, eligibility criteria that I'd like to expand to younger people, to allow methods so people could self-refer so that they didn't have to interface with the justice system at all if they chose not to. Those would be some of the highlights of what I would change if I were doing it the second time. My second point is that I would like to see restorative justice and criminal justice be better partners. If you ask the people in the conventional justice system, the traditional justice, they will say, oh, well, we know all about restorative justice. We're already doing it. And what they think of is they're already doing in restorative enhancements of the adversarial process. What I'm looking for in better partnerships is that we offer people a menu of choices so that prosecutors don't have to make that all or none decision of no action is going to be taken, case closed, which is pretty much all rape cases. And that judges and juries don't have to sit and agonize to reach the 13% rate of guilty verdicts that characterize rape trials in the United States. That's a lot of trauma for a little bit of output. So in terms of being better partners with criminal justice, I'd like to see restorative conferencing be available as diversion. I'd like to see it be available as part of plea agreements. I think that in addition to using it as an option for cases that are being actively pursued, there are other options for where it could be productively placed. My third point that I'd like to see happen in the future would be that we become better partners with advocates and the rape prevention, rape crisis and prevention agencies in our community. Kate has taught me this through her work, and it's expanded my viewpoint that if we partner with coalitions against sexual and domestic violence, if we partner with these local agencies, we can reconceptualize justice for many people as being part of wellness. I think we all have to recognize that justice is not necessarily the first thing a victim is worried about. I mean, because you're victimized by rape, first of all, that unfortunately may not be the worst thing that's ever happened to you in life. And second of all, you may have lots of more pressing problems like food, housing, childcare, employment, and so forth. So for that reason, I think we're a little bit arrogant when we think, oh, well, what we do is so important. It's the hub of the whole wheel. It's not. I'd like to see us reconceptualize the possibility that justice services become part of the wellness agenda of a rape crisis center and become one of the services that we offer to victimized people. And then my fourth and last point is that it was such a pleasure to do this webinar today because the work we all do has no meaning unless it translates into advocacy and policy stemming from legislative and statutory change. It's rewarding to try to be working in that direction. And it's my sincere hope that we won over some minds today that we can build our connections and pool our energy in the direction of trying to influence how Violence Against Women Act money is spent, how rape prevention education money that flows from VAWA through the CDC to the states, how that money, how the agenda for that money is thought about, because restorative justice is either forbidden, as Elise pointed out, or it's left out in the cold. And we got to change that because we got to move away from two things. One, the illusion that we do anything serious about rape accountability. And two is we have to do something about the fact that when we impose accountability, it is oftentimes disproportionate in the sense that it's lifetime and it ruins people's lives. And I don't think that many of us share a belief system that excludes the possibility of rehabilitation, repentance, and the ability to reintegrate as a law-abiding person. So those are my hopes and dreams for the future. And I think Elise is next. Oh, no, I'm sorry, Danielle.
No, you're correct. We are going to pass next to Elise. So Elise will bring you on up. Awesome. And share your reflection with us next.
All right. You know, on college campuses, we have the major goal of turning young people predominantly into safe, responsible, healthy, happy adults who are going to go out into the world and do good things. That's our hope for all of them. And where in this position where we have a responsibility to all students on our campus, whether they have been harmed or whether they have harmed someone in these situations. And we have whole layers of different policies, laws, regulations, things like that that we have to follow in order to protect all students. And I really think that some of these very hairy issues that campuses have had to deal with for years could be well addressed by restorative justice options. So, for example, FERPA protects people's educational records. And for somebody who's been reported and found responsible of sexual misconduct, that goes in their educational record and it's private. So what that means is for victims on college campuses who've gone through an adjudication process that may have been more re-traumatizing for them, if the person is found responsible, they may or may not find that out, and they certainly do not find out if or what types of sanctions happen to that person. That can leave a huge hole and kind of rip out that sense of justice for survivors, for victims. And at the same time, FERPA protects the educational record of a person who's been found responsible, which is the right thing to do in those instances. So there's that. And we also have to deal with the fact that the national data do not support the idea that most rape on college campuses is perpetrated by serial rapists. So a few bad apples doing all the raping. It just doesn't support that. And so what that means is we do have, or what we see is this huge bias against students who have inflicted sexual harm. Do serial rapists exist? Absolutely. Do absolutely horrific rapes happen on college campuses sometimes, like we see in the news? Absolutely. But for the vast majority of students who are reported and who are found responsible ultimately, or who admit to what they did, they do not have some kind of static psychopathology that prevents them from being rehabilitated or from changing if we have the right systems, the right accountability processes that allow that to happen. And so can we create a system through restorative justice where we can help victims to have a sense of justice, maybe even some sense of closure at some point, while also allowing somebody who has harmed someone else to have dignity in that process and to have dignity in taking responsibility and being held accountable? I think we can do that. You can also use this process to address the feelings of family and friends of both parties who've been affected by this harm. We've had administrators in one study we did a few years ago who said, one of the issues we see is, especially with international students, the stakes are very high for being found responsible for sexual misconduct. So in an intimate relationship, if there's dating violence, sexual violence happening, a student may not report their partner because they don't want their partner to be found responsible and lose their visa, but they want the violence to stop. So how can we create a process such as restorative justice that will allow that to happen? And I could go on, but I think though I would love to see this proliferate on college campuses. I would love to see students informed of their options so that they know they have a wider menu of options to choose from, depending on what they want to see happen. Thank you.
Thank you so much, Elise. We'll pass to our last panelist, Quince.
Thank you, Danielle. And to build on what Elise said, our system, our criminal legal system, I'll call it criminal legal system, drawing on some other legal scholars' approach to it rather than the criminal justice system. The criminal legal system, because it's not always just, tends to emphasize punishment and not sort of lost sight of the idea around rehabilitation. And so I come at my work both from Restore, but then also in my current work from that public health perspective that Mary mentioned, where we're looking at prevention of violence and what is it that we can do to prevent violence. And there are two tenets that really guide my work. And one of them is from Sonia Shai, who's with the Ahimsa Collective. And she has a phrase, she says, hurt people hurt people, which is just a reflection of the fact that if we don't address sort of causes of violence and causes of someone engaging in harmful conduct, then we are not doing everything we can do to prevent future things from happening. And the other is, and this is something that Donna Coker at the University of Miami Law School has talked about, is that sort of cognitive dissonance within the criminal legal system. This idea that we are going to punish, right? That we are going to inflict harm on someone else by punishing them as a way of remedying harm that's been done. And there's just this cognitive dissonance that the legal system would be a perpetrator of harm in that kind of way in response to harm. It's sort of compounding harm rather than trying to mitigate harm. And what restorative justice has the promise of doing is to mitigate harm rather than cause additional harm. Mary talked about some of the outcomes in Restore for participants where it was no enhanced harm, no critogenic harm, to use the legal term, law-caused harms. So what I want to really advocate for is this notion of prevention of violence, prevention of sexual violence in both primary prevention and secondary prevention, where primary prevention is around education, secondary prevention would be responding to lower, and I almost hesitate to use the word lower, but less egregious, say in the eyes of the law, less egregious forms of harm that might not rise to the level of a crime, but that might constitute sexual harassment. And so in particular, I want to refer to the research by, recent research by Dorothy Espelage and her team and others, American Association of University Women, who have demonstrated that the rates of sexual harassment at the middle school level are the highest. They tend to drop off after that, but at the middle school level, approximately 50% of both boys and girls experience sexual harassment. And what we know from others' research is that sexual harassment is a risk factor. It's a marker of some future potential more serious violence, such as sexual assault or rape. And because of that, we really need to be intervening early. We need to be intervening in 6th, 7th, and 8th grade when young people are starting to explore boundaries. They are testing things, they're testing limits, they're starting to engage in interest in romantic relationships of some sort without necessarily knowing what that looks like, and stepping over the line, stepping over boundaries when they don't necessarily know that that's what they're doing, or there's a lot of peer pressure involved. And so engaging in education, using some of the skills and restorative practices, using circles as an educational method as we're delivering violence prevention information and education, and then responding to those types of sexual harassment that are occurring at the middle school level because they're predictors for more serious violence later, and responding to them with restorative justice conferencing, which in and of itself is an educational process to help those young people who don't necessarily understand yet fully the harm that they're causing and the behaviors that they're doing, but that there's still accountability. There's accountability, but there's also learning, the opportunity for rehabilitation and making things right, and preventing future incidents of violence. So that's really my hope and my dream, is that we will really be intervening as early as possible, engaging in prevention work, using our lessons from restorative justice in restorative justice responses to incidents of harm, but also using these skills and techniques and practices in our educational processes as a way of preventing incidents from happening in the first place. Turn it back to you, Danielle.
Thank you so much. I just want to continue to reiterate my thanks on behalf of myself, but also for our attendees who are still here. We have been learning and hearing so many good things. We've discussed trauma, its impact to those who have received harm and those who have offered harm. We have discussed the lessons learned from, the Restore program, from on-campus programs, and of course, the legal entities. I am going to encourage our panelists to turn their camera on, and I am going to start asking questions. Our very first question that we received today really asks about age, right? Have the studies done on restorative justice talked about participants with victims that were 10 or younger? Can anyone field that question about? I see Mary nodding. We'll pass to you, Mary.
Yeah. Early studies done a number of years ago in Australia looked only at juvenile justice. So there exists a fairly significant literature. The author of it is Kathleen Daly, D-A-L-Y, and it's easily obtainable. I'll write it in the chat because she's got a website that has every word she's ever spoken on it. So there you can find out the documented results of using a conferencing model through the criminal legal system with adolescents, and with, I'm not sure how young they went, but it was pretty young.
I can add a little bit. Outside of the discussion of sexual harm, we know that restorative practices are a great tool to get young people to feel comfortable and encouraged and to feel like they have place and space to offer voice. And so just the framing of the tool in and of itself, right, is used in many non-harm settings where we're just trying to get young people to feel encouraged. And so this tool, I can't remember which one of you mentioned it, but we see this in school K through 12 classrooms. Is just regular opportunity to engage and improve community and conduct issues as a whole. Did anyone else want to comment or about the 10-year-olds, the younger persons? Okay, I'll move on to, oh yes, Quince.
Just, I definitely, I think that's a great question, and I really appreciate Mary sharing Professor Daly's work as well. I definitely would agree with Mary 100% about that, and with you as well. This is really, really important, and it's amazing watching young people soak it up and respond to it well. I mean, they're amazing to watch. I can certainly say that from our work with the sixth, seventh, and eighth graders.
Let me move to our next question. One of you mentioned, right, and it might have been the Restore program, but feel free to correct me, that there's a one-year process. And the question that was being asked is, what happens with the formal court processing? Is the criminal case put on hold so that the one-year process that is the restorative conferencing can take place?
The agreement we had with the prosecutors was that the referral to the Restore program was intended to be a resolution, so that if the program was completed successfully, there would be no further criminal actions. There was like the exception was for misdemeanor crimes where there had been a plea entered prior to coming in the Restore program. But you guys in the criminal legal system have to help me because I forget the proper name for it. The case was dismissed with prejudice and vacated, so that the person that successfully completed the program then had no record of conviction. Now, that said, well, what happened to the people who didn't successfully complete the program? I'm sad to say that they all went back to the prosecutor's office, and since with Quince's help designing the right kind of process, we did not create double jeopardy, and there would have been an opportunity for prosecutors to pursue further action to these people who did not successfully manage the gift of being able to participate in a non-adversarial, non-carceral system. But I'm sad to say that the prosecutors took further action in 0 cases.
Thank you. I'm going to pass on to our next question. We've got a question that says, what do you think the percentage of different sexual offenses in criminal cases could be diverted to some sort of restorative justice process? So I think it might be helpful because we've got a lot of expertise. Maybe Elise, if I could ask you first, like from a campus perspective, is it some, all, none, and then if anyone would like to answer more generally, we'll answer after that.
Sure. From a campus perspective, I think that a huge proportion, maybe the majority, could be diverted to restorative justice if students felt safe to do so. I think it would take a little while, for them to understand what this is and whether it's a safe option to pursue, especially for folks who've been reported. I think, it would definitely take some time, but I think a lot of cases really could go that route. It's not the majority cases that are these very violent, horrific types of cases where somebody is going to be permanently excluded because they're not safe to retain at an institution. That said, I have a comment on the criminal legal system as well, but I will defer to other folks on this, is that we know that a whole heck of a lot of victims do not report to the criminal legal system. And so it may be that there are more severe cases where folks are calling law enforcement. And so I think that's something to consider as well when we're thinking of how many cases from criminal legal could be diverted. I wonder if there was a self-referral option, if people who did not feel like, well, I don't want to call law enforcement for whatever reason here, if there is another option, could we see a lot more that way? So I think that's a consideration potentially as well.
Excellent points. Does anyone want to add on or provide a more general perspective? I see Quinn's here.
Yeah, I'm not so much with adults, but I just want to say with youth, because that's kind of my focus now, is I guess I'm a strong advocate for restorative justice for almost all youth offenses. There's very little that I would say that young people are going to engage in that really justify the kind of heavy hand of the juvenile legal system. Certainly there are times when maybe that's what's needed, but for the most part, the kinds of things we're talking about that are happening with, and certainly within the middle school age, maybe as you get into later in high school where things get more serious, maybe you'd have a different result. But I'm a strong advocate for restorative justice for most youth offenses.
I would just add that last year, I don't know, it's a pandemic, so maybe it was 2 years ago, One Standard of Justice, we, in collaboration with other community partners, put on a restorative justice conference and really also address some of the research behind like vicarious conferencing and what does it mean to maybe not want to confront the person who directly harmed you, but still the opportunity, especially once time has passed and work has been done, to still grow from those opportunities. So I would say, from my understanding, the literature is continuing to try to grow and stretch and ask itself, what's the best way? I think you nailed it, Elise. What's the best way to make the people who are involved feel like they have what they need so that they can comfortably move forward, so that it's not meant, of course, to be coercive or any sort of way like that. So then just making sure that we're providing the right supports to people as they move forward. I will move to our next question. Our person. Oh yes, Mary.
Can I just say one thing that your thought stimulated, and it oh God, I got so upset about, was it right to interrupt you, that then I sort of forgot what I was going to say. Well, hopefully it comes back soon. And
it will come back, and don't worry, I'll make sure that we come back to it, right? My pass to our question in the chat is,
now I do remember it.
Okay.
Thank you for giving me a little pause. All of us come from victim advocacy backgrounds, and therefore want to really make clear that we don't endorse using restorative justice unless it is without coercion on the victim. And in our program, we gave the victim the first choice. And if the victim said, this does not appeal to me, that was not offered. There are other countries where they do not treat victims like that within even the conference model of restorative justice, where they will call up the victim and say, your perpetrator is going to be in restorative justice and the conference is tomorrow. Do you want to come or not come? And to me, that's definitely not what we stand for. So it's really important to emphasize not only to victim choice at every level. And
I think that's
otherwise,
such
you
an
don't end up
important-
with empowerment.
That's such an
Sorry.
important clarification. I just was eager to agree with you. You know, in the state of Connecticut, we have a very robust victim advocate community. And part of the conversation is how do we make sure we're not diminishing victims' voice, victims' rights as we continue to try and innovate public safety and try and innovate ways to not just unnecessarily be punitive to those who are caught in the system, but also wanting to hear more about what it is that victims feel is most appropriate in the pursuit of repairing the harm that's been done to them.
The people we most often used as victim representatives were either rape victims themselves, and so they could speak from their own, sources of knowledge. And then we also used advocates, and the advocates were our harshest critics. So when we and it was for all those kind of concerns that you're talking about. When we got 60% satisfaction from the representatives of the victim, we thought this is about as good as you can hope for, and it's a starting point. But once the victim representatives / advocates got a chance to see what happened in a conference, they were much better equipped. I'd just love to share one story with you that all my colleagues have heard so many times that they're going to fall asleep. But one of our conferences, we had a prosecutor attend, and after the conference's end, we ushered the responsible persons party out of the room, and the victim survivor party stayed, and they talked and they debriefed and shared with each other, and we had cookies and stuff so that it was kind of like could be a social occasion, not to make light of it. But the prosecutor spoke in my ear and she said, "I have never heard a rape victim laugh before. I've never heard a rape victim laugh before." And to me, that was such a meaningful statement, that you could conduct a process where afterwards the victim felt such a sense of relief that they could be with their family, they could be with their friends, and they could, feel that sense of real happy life coming back to them.
That's such a testament to the emotional work that it is to be involved in restorative justice and restorative practices. The goal is to provide people, both once again, those who have received the harm and those who have offered the harm, a chance to move out of that negative affect of shame, of guilt, of burden that comes with victimization. And so I just think that your story really highlights really the opportunity that restorative practices bring to the criminal justice setting, but also well beyond the criminal justice and legal setting. I do want to make sure, I know we're over time, but we've got just one last question, and the person who asked it is still here. So why would we not give the people what they want? The question says, in my community, the local DV and SA agencies, right, domestic violence and sexual assault agency, is moving in the direction of creating a family justice model that would house police officers and lawyers within the nonprofit office as a way of minimizing the trauma survivors experience when interacting with the criminal justice system. What are panelists' thoughts of this model? Any thoughts about, does this create opportunity or does this create more contact with the criminal justice system, which from some perspectives is not what is sought.
I'm gonna go
Quinns, I see you're ready. Yep.
right with Mary's thumbs down. I mean, there's a lot of talk and a lot of discussion within the restorative justice community about is it really an alternative to justice if it's baked into the existing system in that kind of a way? And so I would agree with Mary. I don't think that's, I mean, sure, from an advocacy perspective, as a victim advocate perspective, as a lawyer for for victims, I see the draw of that. But in terms of something being a restorative justice model, I don't think that would be it. And it would not be my first choice. I don't know if other folks have thoughts about that.
No, and I think that there's, so much discussion that's going on for a number of years about the negative effects of having police officers assigned to schools, because it's taken so much responsibility off of schools to use an educative approach to deal with misbehavior, and criminalized and shunted into the justice system so many kids that are doing things that are wrong, but they're, in a developmental context, not something that's totally unexpected. So that would be my fear of this proposal is just to echo what Quince said, is that it's not really going to change anything. That because its goal is to get people more comfortable to use the criminal legal system. And that's not what we're here advocating for. Our goal is to offer alternatives in appropriate cases.
Our participant is in the chat letting me know they're very appreciative that you all have taken time to address their questions. I just want to, it's 5:09. I'm going to give our final thanks to the audience and to our panelists. So first, to our panelists, thank you all. The work that we're doing here in Connecticut, it is progressive, but it requires us to continue to tap into our local community, our state community, our national community, and our international community to continue to stay innovative, to continue to address the misconceptions and the myths that we know exist, both as in simple relation to the criminal justice system, but also the arrays that exist in terms of where is restorative justice, where is the research you all so thoughtfully discussed, where we are both in the scholarship, but also in the legal practice of trying to engage with this work. You have definitely provided our state a great resource. Just to remind everyone, this is a recorded session. If you have registered for this event, we will be contacting you to make sure that you have the resources that we've shared in the chat, as well as if you want to follow up with any of our panelists. We thank you for your time. Our next session, I believe, is on May 3rd. And so I will wait for us to promote that to you formally, but just know that this is a multi-part series and we still are cooking. And so we look forward and we thank you all for your time. Thank you so much, everyone.
Thank you.
Thank you.